The fourth point on why litigation is expensive is the procedure that must be followed during the litigation process, especially in civil cases. First of all, you'd issue a summons or an application in the form of a notice of motion. You'd serve the respondent. The respondent must be given a chance to respond. Thereafter, you may reply. The same thing applies when you issue a writ of summons. The defendant must be served. The defendant is allowed time to respond. And as a plaintiff, you are allowed time to reply to their response. Before those stages can be accomplished in full, there is room for technical points to be raised by the respondent or the defendant. They might allege that your papers do not disclose a course of action, a case to respond to, or that there's some irregularity in your papers, or that your papers have been badly drafted. That would force you as a plaintiff to withdraw your application or your summons and correct it, or it would force you to file an amendment and then serve the other party. And when you withdraw your application or your summons, you are supposed to pay costs to the respondent or the defendant. Why? Because you've wasted that time. This is why you are expected to pay costs. So if your papers are badly done from the onset, if the respondent highlights that fact, you have no choice but to withdraw or ask them if they can allow you time to correct the papers without demanding costs for wasted time.